This has almost turned into my favorite part of the week. It really has. The part of the week where a podcast gets released that I actually listen to all the way through to the end. I pause it, I spit out my coffee or vodka, whatever it is I'm drinking at the time. That was a joke, by the way. That's my ex-girlfriend out there. And I get to pick apart this podcast. And I think it's brilliant. I think the bloke who does the interview is brilliant. And you know what's funny? I just can't get over it enough. It makes me laugh. For years, people have been taking little digs at me behind the scenes on Facebook, in comments, in private messages, on podcasts about my fees, about what I charge, about how I run my business, about what I do in court. And that's fine. I've got used to it now over the years. Seriously, it's fine. It's fine. I can live with it. Because if you're prepared to criticize me publicly, you should be prepared for your own words to be looked at publicly as well. And that's how this works. You see, I'm not making this video because I dislike Simon Wallen. I don't even know him. In fact, there's quite a lot in his interview that I actually agree with. But if you're going to sit in front of a camera, present yourself as someone educating vulnerable parents and make absolute statements about the law, then those statements deserve to be examined. Not twisted, just not taken out of context, just examined. Because that's exactly what I've had to deal with for years. So people have picked apart what I've said, criticized my opinions, questioned my business, questioned my prices, questioned my methods, questioned my mentality. And it's fine. So let's have the same standard for everyone. And before anyone starts dishing out, I'm dishing it out, but I can't take it. I've just recorded a part of a podcast with this very channel. Yeah. So when that comes out, you can sit there for 3 hours if you want and pause every sentence, pick holes in everything I've said, challenge every opinion. I'll get something wrong, I'm sure. And if I do get something wrong, I'll own it. And that's the difference, because this isn't about winning an argument. It's about getting the facts right. Parents don't need cheerleaders. They don't need personalities. They need accurate information. So that said, let's see how accurate this interview actually was, shall we? So let's start fair before anyone starts typing, "No, you've taken this out of context. Oh, I've listened to the whole interview. Not a clip, not a short, not a reel, not a TikTok, the whole thing. That's meant I had to sit there for longer than 30 seconds or 3 minutes. And there were genuinely things I agreed with in this. Yeah. So don't guarantee outcomes. Absolutely. Yeah. Don't tell vulnerable parents what they want to hear just to get their money. Absolutely. Completely agree. Help people understand the process. Absolutely spot on. Be realistic about what the court might do. Can't argue with that. Again, fair play. No argument from me. So this isn't one of those videos where I'm just going to pretend everything he said was rubbish, because it wasn't. There were some sensible observations in there. But here's where we part company. You can't build credibility by saying 10 sensible things and then expect everyone to ignore the 10 things that you either contradictory, misleading, or simply wrong. That's not how this works, especially not in family law, because parents don't watch these interviews for entertainment. They're scared. They're looking for information. Some of them haven't seen their kids for months. Some of them drowning in allegations. Some are about to spend thousands of pounds they can't afford. Some are desperately looking for anyone to tell them what to do next. So words matter. Accuracy matters. Oh, and if you're presenting yourself as someone with decades, and I mean decades, 25 years, I think you said, 25 years of experience, people are entitled to assume what you're saying is legally accurate. That's a big responsibility. Now, one thing you'll notice throughout this interview, there's a pattern, an absolute pattern, absolute statements. You can't do this. You can't do that. This is a red flag. That should never happen. Family law rarely deals in absolutes. Anyone who's spent enough time in family court knows that. There are principles. There are rules. There are expectations. There is judicial discretion. That's why sweeping statements can become dangerous, because they sound brilliant on YouTube until someone relies on them in a real case. And that's why we're going through this. Not because I dislike Simon, not because I'm trying to score points, but because if someone publicly comments on how other people operate, their own public statements should open to exactly that same scrutiny. Fair is fair. So let's begin with something that's really caught my attention. Now, this is interesting. Apparently, charging a lot of money up front. It's a red flag. Jeez. Right. That's a big one to start with. Let's start with that absolute bombshell, shall we?
But how do you know who has that experience other than asking them? And people aren't always honest. I don't know. I think if they are guaranteeing an outcome, that's a red flag, because you cannot do that at all. If they're asking for a lot of money, that would be a red flag to me. If they're asking for a lot of money up front, that would be a red flag. I do find it a difficult question to answer because you're going into something that you don't necessarily understand or know what to look for.
Mhm.
Apparently, yes, like I said, charging a lot of money up front, red flag. Okay, really interesting. That's it then, is it? That's it. Case closed. Nothing else to say. What? Okay then. Right. Okay, that's fine. So how much is a lot exactly? I mean, go on, please share. Give us a number. Please do. 500 to £20, £50, 1,500, 5,000, 10,000, 3,000, 20 quid in a Tesco meal deal, a Kentucky Fried Chicken with a packet of chewing gum. Where exactly does the official red flag scale begin? Has Ofcom published a chart yet? Is there an ISO standard for too much? Or is it just another one of those, trust me, bro, type things? You know, that's what we've got to do. It's one of the moments in time. Because this is what fascinates me. People make these statements, they're big statements with absolute confidence and never stop to explain them. A lot. Compared to what? Compared to who? Compared to how much? Compared to how much work? Compared to how much experience? Compared to what outcome? Because price on its own means absolutely nothing. A Ferrari is expensive. Rolls Royce is expensive. Heart surgery is expensive. I'd be more worried if heart surgery was $39.99 and come with a free delivery. You don't judge value by looking at the price tag. You judge it by asking, what am I actually getting? Here's another funny one for you. Apparently paying up front is suspicious. Tell that to, I don't know, your solicitor, your barrister, your accountant, the locksmith, your builder, your holiday company, your mobile phone provider, Netflix, Amazon Prime, the family court itself. I mean, the last time I checked, HMCTS doesn't say, pay us after the hearing if you're happy with the service. No. They want the fee first. It's funny that, isn't it? Funny that. So maybe, just maybe, the issue isn't paying up front. Maybe the issue is whether someone has been honest about what they're going to do for that money. Now, that's a sensible discussion. When work is included, how many hours, how many hearings, how much preparation? What happens if the case changes? How many applications? What's excluded? How many hours per week? Can you actually do what you're promising? See, those are consumer protection questions, not, I don't personally like deposits, because that's all this is really. It's a preference, and that's absolutely fine. You're entitled to your preference. I'm entitled to mine, but don't dress a personal opinion up as if it's some universal rule that every vulnerable parent should follow, because there are plenty of excellent professionals who charge up front, and there are plenty of terrible ones who don't. The invoice doesn't tell you who's competent. The invoice doesn't tell you who's ethical. The invoice doesn't tell you who's experienced. It tells you what they've asked you to pay. Nothing more. And here's the bit that really gets me smiling. Throughout this interview, we're told to avoid sweeping statements. Don't make guarantees. Don't overpromise. Don't speak in absolutes. Excellent advice. Excellent. Then, guess what? 30 seconds later, if they ask for a lot of money up front, that's a red flag. We've gone from every case is different to here's a one-size-fits-all rule. Then that didn't take long, did it? No, wait.
I've written what I think they should send. They will check it, maybe change it if they need to, and send it. I can't send that email for them to the solicitor because that's litigation. So I can't do that. I can't sign papers for them. I can't sign application forms for them. I don't even post application forms for them. I get them to do that. The largest thing and the biggest obstacle really is the speaking in court. Now, you're not allowed to address a judge. I have done it many, many times, but then I've got a lot of experience and judges know me and judges do get to know you after time. But then that creates a bit of an issue in that if things don't go well, the client is going to be unhappy with you. But then your client isn't, and I see this so often, they're not able to express what they want to say clearly and properly for a judge. And it's the speaking in court, which is...
Well, say that again. Now, this is where I had to rewind the interview a few times because I genuinely thought I misheard him. He starts explaining what a Mackenzie friend can and can't do. And it's fair enough. Good topic. Parents need to understand the boundaries, limitations. Then he says, and this is what me, you cannot speak in the hearing to the judge. Right? Good. This is fair. As a general rule of thumb, that's it. Right? That's broadly where the law starts. No general right of audience. Fine. Then, literally, moments later, he says this. Now, you're not allowed to address the judge. I've done it many, many times. What? Sorry? What? Let me play that back again. Let me just rewind that a second. You can't, but I've done it many, many times. Which one are you going to go with? Because They can't both be your opening statement. That's like me saying, ladies and gentlemen, drink driving is illegal. Now, I've done it loads of times. You don't get to make an absolute statement and then immediately appoint yourself as the exception, please. Now, before the comments explode, yes, I understand there are circumstances where a court can grant a layperson permission to address the court. That is true. But that's the important bit. Permission. Permission. Not, I've been around a long time, I'm a dinosaur, they know me, I'm really fine. Not, that's all right, Jack, I've got it, Jack, the judge knows me. Permission. Those aren't the same thing. Imagine getting pulled over by the police. Do you know why I stopped you, sir? Do you know why? Yeah, but it's all right, officer. Don't worry, it's all right. I know. The speed camera knows me. It's all good. See how ridiculous that sounds? Experience isn't permission. Reputation isn't permission. Knowing people isn't permission. Permission is permission. And that's why words matter. Because a frightened parent listening to this interview could quite easily come away thinking, oh, if I get experience enough, I'll be able to stand up and speak for people. No, darling, no, that's not going to happen. That's not how it works. Then we get the other one. We get another one. He says, you can't write letters on behalf of someone. You can't write letters on behalf of someone else. Okay. Then almost in the same breath, I always write the suggested letters. I always write emails. I always write statements. Hang on. So you don't, or you do, but you do? This interview starts sounding like one of those old Abbott and Costello sketches. I don't write letters. I write the suggested letters. I don't send emails. I write the suggested emails. I don't speak. I've spoken many times. By now I'm sitting there thinking, Jesus Christ, am I watching this legal interview or what? Is this an episode of Would I Lie to You? Now, before everyone starts twisting their lemon and what I'm saying, there's a perfectly sensible distinction here. Helping somebody draft something isn't automatically the same thing as formally acting on their behalf. Those are different concepts. And that's exactly why the precision matters. Because if you're educating the public, you don't get the brownie points for being vague. You have to explain the difference. Otherwise, people leave more confused than when they arrived. And here's the pattern that's beginning to emerge. Everything is absolute until it isn't. You can't, unless I have. It never, except when it does. That's not clarity. That's confusion dressed up as certainty. And we've still got 40 minutes left. Whew. Apparently, everything's a red flag. Now, here's something I also noticed. This interview has more red flags than a Chinese military parade. Everything is apparently a red flag. Charge too much, it's a red flag. Charge too much up front, it's a red flag. Guarantee an outcome, guess what? Red flag. Red flag. Testimonials. Whew. Testimonials, well, I don't really trust those either. Directories, well, question them. Networks, whoa, jeez me. Question that. Ask who accredited them. If it's me, it's all right, Bob. If it's not, well, question that as well. At this point, I'm thinking, has anybody passed the Simon Wellen background check yet? Or are we all just wandering around the family courts waving giant red flags at each other? Because here's the problem. Healthy skepticism is good. Blind skepticism isn't. There's a big difference. A big difference. If I tell someone, ask questions before handing over your money, brilliant advice. Ask what's included. Ask what experience they've got. Ask how they work. Ask what happens if your hearing changes. Ask what support you'll actually receive. That's common sense, if there is such a thing as common sense. But if your message slowly becomes, don't trust testimonials, don't trust directories, don't trust accreditation, don't trust what people charge, don't trust what people say, eventually people are left wondering. So what exactly am I supposed to trust? And here's the funny part. The only person who never seems to trigger one of these red flags is the bloke describing all the red flags. Convenient, that, isn't it? A bit like a bloke selling burglar alarms, telling you every other security company's dodgy. Maybe they are, maybe they aren't. But I'd still want some of the evidence before I started nodding along. Because one thing I've learned over the years, anyone can say anything. Anyone, I'm one of the good ones. I'm one of the fucking best ones. Whatever, anyone can do anything. The internet's full of self-proclaimed experts. The UK's number one, the leading authority, fastest growing, most experienced. Apparently everyone's number one. Woo! Well done, everyone. Well done. If all those websites are true, there must be about 47 number one Mackenzie friends in England. It's incredible. Absolutely incredible. We've achieved something mathematically impossible. And that's why I don't buy into personality. I don't buy into branding. I don't buy into confidence. I buy into evidence. Show me your reasoning. Show me the law. Show me why you've reached that conclusion. Because if your entire argument boils down to, trust me, I've been doing this a long, long time. Well, I've met people who have been driving for 40 years. Some of them still can't reverse into a parking space. Time served. Isn't that the same thing as being right? Experience is valuable, really valuable. But experience without accuracy is just confidence that's been around for longer. And if you're asking vulnerable parents to trust you, I don't think that's an unreasonable standard. Don't ask me to believe you. Show me why I should. Another one. Opinion isn't the law. Now, this is where I think the interview starts drifting away from, like we say, here's my experience, into this is how family law works. And those are not the same thing. Because once you start explaining the law, people assume you're explaining the law, not giving your personal take. This one. If you live close to each other, there aren't any issues, you're very likely to get 50-50 care. Really, very likely. Based on what? That's a lovely soundbite. Lovely. But that's not how family law works. The court doesn't sit there with Google Maps open and go, well, what are you, 2.3 miles away from each other? Equal care it is then. Go on, crack on. That's not the legal test. The court looks at the welfare of the child. Every case turns into its own facts. Distance might matter. School might matter. Work patterns might matter. The children's wishes might matter, depending on age. Health might matter. Practical arrangements might matter. There are loads of moving parts. So, saying you're very likely to get 50-50, your next door neighbours, woo, that's not educating parents. That's giving them an expectation. One of the things you said you shouldn't be doing before the court has even looked at their case. Then we move on to the solicitors. And I don't even like solicitors, but apparently solicitors ramp up conflict. Well, yeah, I can buy that. They're brilliant. Yeah, I'll buy that too. Barristers don't prepare cases. That depends. That's questionable. They just stand up and argue for them. Really? Come on now. I know quite a few barristers. I imagine they'll be delighted to discover that they've apparently never drafted advice, never prepared arguments, never worked through paperwork. Someone should tell them that. Jesus. My gosh. I mean, they've clearly been wasting all those evenings preparing cases. I mean, look, you can criticize solicitors. I criticize them all the time. I make no secret of it. I don't think they should be in family court. Yeah. You can criticize barristers. Again, I don't think they should be in family court. You don't need them. You can criticize judges. I mean, I criticize judges, but unfortunately we do need them in family court. But if you're going to criticize the entire profession, at least criticize them for something actually true. Then like their costs. Yeah, that's worth it. But let's talk about their costs actually. Yeah, right, actually their costs. Apparently costs don't really come up in family law. Costs against the other party. That's right. Costs against the other party. No one has to ever pay client costs. Well, that's really wonderful. That's not what my experience. He's been doing this for 25 years. Yeah. 25 years he's been doing this. And apparently he's never come across anyone in a single court case that's had to be hit with costs. I've been doing this for 15 years and I've had 4 people hit with costs. I mean, I just wonder, I'm generally pleased for his clients that he's never had to deal with it. But like, that's not the same thing as saying costs don't arise, because they do. Not every day, but they do. Yeah. And that's the point. Not in every case, but they do. They absolutely do exist. There's a difference between saying, they're relatively uncommon. I've not really had one in 25 years. And saying they don't really happen at all. And everyone criticizes me for me being how I communicate and how I talk, right? This is what makes me laugh more than anything else. I might not be your conventional sort of family law professional, and I am not. And I pride myself in not being like any of these puppets. Yeah, they think that none of them have got their own personality. They think they have to behave a certain way, and that's speaking funny and not being themselves. That's what makes me laugh. Yeah, I digress. Sorry. This is a pattern I've noticed all the way through. Everything gets simplified. Everything gets boiled down into a catchy sentence. Family law is common sense. You're very likely to get 50-50. Barristers don't prepare cases. Costs don't really happen. What the F? That trouble is this. Family law isn't a motivational quote. It's messy. It's boring. It's fact sensitive. It's boring. It's full of exceptions. It's boring. It's full of judicial discretion. It's boring. Sometimes 2 experienced lawyers can honestly disagree about the likely outcome because it's boring. That is the reality. It's boring. And that's why I get nervous when I hear somebody reducing complicated legal principles into bite-sized slogans, because it's boring, because slogans are brilliant for YouTube, but it's boring. They're not brilliant for someone who's deciding whether they will see their child next weekend or not. And that's the difference. I'm not asking anyone to agree with me. I'm asking people to separate opinions from law. I get a bit emotional about this. Experience needs to be separated from authority. Confidence from accuracy. Because if we stop doing that, family law just becomes a competition over who sounds the most convincing. And trust me, the court doesn't hand out child arrangements orders to the person who sound with the best soundbite. Now, here's the real problem. This video was never really about Simon. He just happened to be the bloke sitting in front of the microphone. The real problem is much bigger than one interview, because this industry has become obsessed with personalities. Everybody's got a podcast. Everybody's got a Facebook group. Everybody's the country's leading expert. Everybody's got a training course. Everybody's exposing everybody else. Everybody's throwing little digs. Everybody's dropping little hints. Everybody's apparently knows what everybody else is doing wrong. It's like Love Island, but with witness statements. And here's the irony. The people shouting the loudest about standards don't always meet the standards they're demanding from everybody else. That's the bit that fascinates me. You can't spend years telling everybody else they're wrong, they're dangerous, they're charging too much, they're doing this, they're doing that, and then expect nobody to ever look at what you've said. No, it works both ways. If you want to live by public scrutiny, you've got to be prepared to die by public scrutiny. And I include myself in that. I've never claimed to be perfect. I've got things wrong. I will get things wrong again. When my interview comes out, watch it, criticize it, pick it apart, challenge it. If I say something stupid, clip it, put it on Facebook, laugh at me, correct me, because that's how this should work. Not whispers, not gossip, not little digs hidden in little podcasts, not Facebook posts where everybody else knows who you're talking about, but nobody's brave enough to say the name. If you've got something to say it. And if you're going to say it publicly, don't be surprised when somebody publicly replies. That's not bullying, that's accountability. Now here's the bit I really want parents watching this to remember. Don't believe me. Don't believe Simon. Don't believe the bloke with 50,000 followers. Don't believe the woman with a shiny website. Don't believe the bloke who's been doing it for 25 years. Don't believe anybody. Just because they sound confident. Ask questions. Ask, how do you know that? What's your source? Is that your opinion? Or is that actually the law? Because confidence is cheap. You can buy confidence. You can fake confidence. You can rehearse confidence. You can stick a camera in front of somebody and they say, and they can sound like the cleverest person in the room. Accuracy, that's harder. Humility, that's harder. Yeah. Being prepared to say, I don't know. It depends. I got that wrong. That's where real credibility comes in. Not pretending you've got the answers for everything, because who has? And finally, Simon, if you watch this, don't take it personally. Take it professionally, because that's exactly how I've had to take criticism for many years. And to everyone else who spent years taking little swipes at me, talking about my fees, talking about how I run my business, talking about my methods, without ever actually using my name, congratulations. You've accidentally created this video, because you've reminded me of something. If we're going to have standards, let's have standards for everybody, not just the people we don't like. Parents deserve better than personalities. Parents deserve better than ego. Parents deserve better than gossip. They deserve accuracy. And if accuracy doesn't care whose side you're on, it either is or either isn't. See you in the next one.
A paralegal is generally somebody who is studying law. In fact, anyone who calls himself a lawyer, and I know I call myself a lawyer, is somebody who is studying law or working in law. I tend not to call myself a barrister because barristers are not allowed to advertise, and I don't want to have that problem. I am a qualified barrister. I'm not a practicing barrister though, so I work as a Mackenzie friend. Informal support from a friend or family, there is always a difficulty with family in that they are often very invested in your case. And I can remember years ago when I went to court.
Right, well, I was editing this basically. I finished recording it, and I was listening to the podcast again, and I had to take some more recordings because it is just a gift. It's just a gift. So we got to my new favorite bit, which is the sales pitch. That's right, guys, the sales pitch. Now, look, don't get me wrong. There's nothing wrong with selling a course. I've got courses. I sell them. Yeah, other people have courses. I've got absolutely no issue with that. But don't spend the first half of the interview telling everyone to watch out for red flags, and then suddenly spend the second half of the interview trying to sell everyone something. Because that's exactly what happens. Suddenly, we're hearing about the training course, the coaching course, hybrid course, the mentoring course. He's going to be doing a call once a week because he thinks that's something I do. That's something I've been doing for years. You're talking like it's some sort of new idea. I've been getting criticised for doing this, but now everyone's doing it. Okay. The monthly, like the mock hearings, I've been doing that for years. Where did you get that idea from? The events? Where did you get that idea from? I'm sitting there thinking, This has turned into a bloody QVC special. But wait, there's more. Then he starts listing all what you're going to learn. What do you do if your client gets arrested, he asks. Hang on. Let's stop there. Pause that. What are you going to do if your client gets arrested? Your client's been arrested. What exactly are you going to do? You're not representing them at the police station. You're not giving them criminal legal advice. You're not interviewing a witness. You're not applying for their bail. You're not prosecuting the case. You're not defending the case. So what exactly is Module 7 then? How to look concerned while telling your client to ring a criminal solicitor? That's about it, isn't it? What's lesson 2? Step 1, don't panic. Step 2, this isn't your lane? Because that's the reality. Not every problem belongs to a Mackenzie friend. And knowing where your role ends, well, it's just as important as knowing where it begins. And then we get cross-examination. What arguments are you going to make? What is the judge looking for? What is your ex looking for? What if your client gets arrested? By this point, I'm thinking, are we training Mackenzie friends or auditioning for Silk? Because earlier in the interview, we were told a Mackenzie friend is there to support. Fair enough. That's the role. Then 40 minutes later, we're designing cross-examination questions, planning litigation strategy, talking about hearing tactics, teaching people how to argue points. And then I'm confused. Which is it? Are we quietly supporting litigants? Or are we running a legal version of the SAS, who dares wins? And before anyone twists what I'm saying, there's absolutely nothing wrong with teaching people. I do it all the time. Education is brilliant. I spend my life educating people. That's what it's about. The issue is pretending that there's a simple answer to everything, and there isn't. Family law is messy and boring. Every case is different and boring. Every judge is different and probably quite boring too. Every child is different, which is why I always get nervous when someone starts sounding like they've got a module for every possible situation, because life doesn't work in modules, folks. Imagine opening lesson 12. What do you do if your client gets arrested? Here's my advanced legal analysis. Are you ready? They need advice from someone who deals with criminal law. You're welcome. That one didn't need a masterclass, did it? Then I got completely lost. Honestly, lost. Bamboozled. I had absolutely no idea what he actually does anymore. 1 minute. I'm not really doing this anymore. Yeah, I'm more into coaching. I'm moving away from being a Mackenzie friend. Okay, good. Right. Okay. Fair enough. Good for you. Good luck with that. Then 5 minutes later, I still do everything that a Mackenzie friend does. I was in court last week. Hang on. What? So you're not a Mackenzie friend, but you still do everything a Mackenzie friend does. You're a coach who still goes to court, still helps clients, still helps prepare cases, still attends hearings, still does everything a Mackenzie friend does. I mean, I've got no problem with none of that. Just pick a lane. It's like listening to someone say, I don't drive taxis anymore. I just spend all day driving people around for money. Mate, you're describing a taxi driver. Or, I'm not a chef anymore. I just cook people's meals every night. Trigger from Only Fools and Horses, that's what that is. It sounds suspiciously like a chef to me, mate, that's what it is. Now, maybe what he means is his business is evolving. He's doing more coaching, more mentoring, more training. Fine. I have no issue with any of that. Say that then. Don't hide from it. That's perfectly reasonable. You've copied all my ideas. It's fine. But don't tell people you've moved away from being a Mackenzie friend and then spend the next 10 minutes explaining all the Mackenzie friend work that you're still doing. It's like watching someone trying to rebrand themselves halfway through their own interview. By the end of it, I was thinking, so what are you? A coach? A trainer? A mentor? A Mackenzie friend? Or someone just talks gibberish, waffle? A barrister who's not practicing? All of the above? Because every 10 minutes, the job titles seem to change. And if I'm confused, and I've had to watch it like 5 times, imagine how the parents watching the first time must feel, who've never experienced none of this before. And then he says, who you train? He slags off networks and all this. But he's been doing it for 25 years, and it turns out that he's teaching people to be Mackenzie friends. So who gave him authority to do that? I mean, there must have been someone somewhere. Who signed that off? Can we speak to HR about that?